Good morning. My name is Jim Sandman. I'm president of the Legal Services Corporation, which is the United States' largest funder of civil legal aid programs for low-income people. I spent most of my career as a lawyer in a big law firm. I've seen how the American legal system works for rich people, for corporations, for people who can afford to pay for counsel. And I've seen now in my 6.5 years at the Legal Services Corporation how the system works, or more accurately, doesn't work, for low-income people in the United States. How many people in the room are not lawyers? I want to start with a few basics. Great. I love audiences of people who are not lawyers. I also want to be sensitive to the fact that we have so many people here who are not from the United States. So let me start by explaining that in the United States, as a general matter, there is no right to a lawyer in a civil case, unlike in our criminal justice system. The result is that in the United States of America, you can lose your home in a legal proceeding, you can have your children taken away from you, you can be a victim of domestic violence in need of a civil protection order, and you have no right to a lawyer. There is a civil legal aid system in the United States, badly underfunded, that tries to address the civil legal needs of Americans. What I'd like to do this morning is to explain the current state of access to the civil legal system, to civil justice in the United States. Here's a spoiler alert, it's not good. Give you some facts and figures, and then I'd like to suggest 4 recommendations for how we might hack our way to some solutions that will make the civil justice system more accessible and usable to people who can't afford to pay for counsel. In the United States today, there are about 60 million people who are financially eligible for civil legal aid. The Legal Services Corporation, which I head, as I mentioned, is the country's single largest funder of civil legal aid. We fund 133 independent legal aid programs with more than 800 offices, serving every county in every state, the territories, and the District of Columbia. No matter where you are in the United States, there's a Legal Services Corporation funded legal aid program providing some level of assistance to low-income people. We have a financial eligibility threshold to qualify, and it's a bright line cutoff. It is 125% of the federal poverty guideline. What that means is that in 2017, if you're an individual, you can't make more than $15,075 and qualify for legal aid. If you're a family of 4, the cutoff is $30,750. Imagine that. There are many people who make a lot more than those numbers who can't possibly afford to pay for access to the legal system. It's about 20% of the American population that currently meets that income threshold. The Legal Services Corporation did a study earlier this year to see how effective the legal aid programs we fund are in serving the people who come to them for assistance. Over a 6-week period in March and April of this year, we did what we call an intake census, and we had all of our 133 grantees count the number of people who were financially qualified and sought help, and then to determine what happened to them. 41% of the people who were financially eligible and sought assistance were turned away with no help of any kind. 41%. 21% got some level of service, but a level that the provider determined not to be sufficient for the problem that the person presented with. 28% got full service. So our grantees aren't beginning to meet the need of people who present and are financially qualified. Keep in mind what I said before, there are millions of people above these income thresholds who don't qualify for legal aid and who nevertheless are shut out of the system. One of the most alarming statistics about the problem of access to justice in the civil system in the United States today is the numbers of people who show up in courtrooms across the country without counsel. The National Center for State Courts estimates that in 70% of all civil cases in state courts in the US, one or both parties doesn't have a lawyer. Those numbers are far higher in certain kinds of cases, particularly high-volume, high-stakes cases like eviction cases in housing courts. It is common in the United States for more than 90% of tenants facing eviction to show up in court alone, without a lawyer, even though more than 90% of landlords do have a lawyer. It is common for more than 90% of parents in child support and child custody cases not to have a lawyer. There are family court judges across the United States who will tell you it's the unusual day when any lawyer appears in their courtroom. It's estimated that every year 4 million people appear in the courts of California without a lawyer. 1.8 million people appear in the courts of New York State without a lawyer. When that happens, when a person who can't afford a lawyer is forced to navigate our legal system, what they confront is a system that was created largely by lawyers for lawyers, constructed at every turn on the assumption that you have a lawyer. Everything about our legal system, from the language of the law, to the forms that are used, to the rules of evidence, to the rules of civil procedure, were created with lawyers in mind. This system makes no sense to people who are not trained in the law. It shuts them out. It's unfair. And it mistreats them in matters that affect their livelihoods, their families, their safety. That's not right. We need to do something about it. Let me give you just 4 examples of the kinds of barriers that unrepresented people face in the United States when they go to court. One is a wide-scale problem. The other 3 are just anecdotes, but I think they illustrate the magnitude of the problem. The widespread problem is that in many state courts across the United States, there are no standardized forms in use. You will find that courthouses in different counties in the same state use different forms for the same kinds of legal proceedings. In fact, in some states, you will find different forms used in different courtrooms in the same courthouse, depending on the preference of the individual judge. This is a particular problem in jurisdictions where judges are elected, and where there seems to be a notion that each judge is a queen or king in his or her own courtroom and can set the rules as they like them. This is a huge barrier for many reasons, maybe most significantly for our purposes this morning because it impedes, it really prevents the development of document assembly applications to make it easier for people to complete forms. You can't be doing this over and over again for every courtroom in the courthouse or for every county in the state. It's much easier to do in those states, and there are many, where there are standardized forms in use. But where there aren't, that's a huge barrier. Now, let me give you some anecdotal examples of barriers. In the state courts of New York, where we are this morning, if you want an uncontested divorce, you have to file between 12 and 21 different forms, the exact number depending on whether there are children involved and whether one spouse is seeking support from another. I've looked at the list of the full 21. Many of them have titles that are incomprehensible to me. I'm a lawyer. I'm not a New York lawyer, and I can't make sense of the titles. Why in the world does it have to be so complicated? Here's another example. Kentucky has a very good website for people who are seeking uncontested divorces and don't have a lawyer. It's a real effort to try to use technology to be of assistance to people. But I came across one section of the website recently that illustrates how big the problem is. There's a section that says, for almost every form that you need to file, you can complete it by hand and file it with the court. There is one form, however, Form VS-300, VS stands for Vital Statistics, that must be typed and printed out and filed with the court. It must be printed, the rule says, on 25% cotton bond paper with a visible watermark. When I read this, I went around my office and I talked to some of my younger colleagues, and I said, do you know what 25% cotton bond paper is? And the majority of them didn't. And I said, do you know what a visible watermark is? Well, today people think of a watermark as like a Microsoft Word watermark. It's the gray draft that you print across your but they've never heard of this idea of holding something up to the light to look for a watermark. This website section then goes on to say this is an effort to be helpful. You can find this resume-style paper at most office supply stores and department stores. Resume-style paper. Well, you know, a lot of low-income people don't have a resume. They complete job applications. It's job by job what they put in when they're applying. And then if you think about it, today, people apply for jobs if they need a resume, they do it online. It doesn't make any difference what kind of paper it is. You scanned it. It's the obligation of the person who chooses to print it at the other end what kind of paper it's going to be on. So then I went online to see how much 25% cotton bond paper costs. The cheapest price I could find, you generally have to buy it in a ream, 500 sheets. The cheapest price I could find was $16.99. The most expensive was $29.99. Imagine you're a low-income person, you need one sheet of paper, and you got to pay $16.99? I don't think so. What is that about? I mean, it's clear to me what the origin of the rule is. This is a vital statistics form where they're trying to ensure authenticity. So they want something that is an original and looks like an original. So it's on thicker paper, it's got a watermark. This is 2017, folks. I can deposit a check with my phone. Why in the world can't Kentucky allow people to get a divorce without 25% cotton bond paper and a visible watermark? And here's one last little example. I heard from a justice of a state Supreme Court about a sign that was posted in a clerk's office that's intended to be helpful to people. The sign reads, "Pro se litigants here." Do you get it? Pro se litigants don't know they're pro se litigants. They don't use the word pro, they don't use the word say, they don't use the word litigant. But this is an example of the myopia that infects the way that we run our system and of its inhospitability to the people the system is intended to serve. The bottom line is this. If you were to design a civil legal system knowing what we know in the United States today, that the majority of people in many high-volume, high-stakes cases would not have a lawyer, you would never design the system that we have. You would start in a completely different place. You would start with the assumption that the user is not a lawyer, that the user not only may not be a college graduate, but may not have a high school diploma, and the system would look completely different. What is stopping us? We know that now, but we persist in forcing people to use the system that we know is inadequate, that does not work as intended for the majority of users in it today. That's not right. So here's what I suggest for how we might hack our way to solutions. Now, I'm going to concentrate just on this phenomenon of large numbers of unrepresented people in civil cases in our state courts. And my 4 recommendations are these. Number 1, you need to start by setting priorities. You can't just attack it from a million different directions. That technology actually today is making a difference, but many of the solutions are diffuse and siloed. They're very uneven across the United States. We need to set some priorities. People might differ on what those priorities should be. My own would be to think big and to start with high-volume, high-stakes cases. When someone is at risk of losing their home, That's a really important case where they should be able to access the legal system on terms that are meaningful to them. I'd also include child support and child custody cases. These are matters that when they go badly for people cause their lives to spin out of control. They have all kinds of collateral consequences, not only for the individuals, but for society and for communities. But maybe I'm wrong. What I'd suggest is that we start the priority setting process by talking to state trial court judges. What are they seeing in their courtrooms? They're in the emergency rooms, the equivalent of emergency rooms in the American legal system. They know what's recommend. So number one, priority setting. Recommendation number two is step back and look at the process you're proposing to automate. And rethinking, recreating that process should be on the table as part of the job of a hacker. If you automate a bad process, you end up with an automated bad process. Automating these 12 to 21 different forms for people seeking an uncontested divorce in the state courts of New York, well, it's better than not having it automated, but you haven't gotten rid of the underlying problem. The system is too complicated. It needs to be simplified. So don't accept the process as a given before you begin to automate it. Step back and think, who do I need to have at the table to be able to address the bigger process issue here? Business process analysis, this is a discipline that the business world uses. We need to apply it to the legal system. My third recommendation, and a related one, is you need to have the right people at the table. That's why I asked how many people here are not lawyers. But our world needs to include business schools, it needs to include designers, engineers, social workers, users, low-income people. They need to be involved. Lawyers alone are not good at this. Even lawyers who are techies. They've grown up in a system that's based on precedent. They're pretty good at tweaking the system, but not at rethinking it completely. So we need to expand the participants in exercises like this and think, who could help? Who's got that perspective? Who's going to know that that crazy sign that says pro se litigants here is not helpful? And bring that perspective to the work that we do. And then finally, I would say that it's very important to build evaluation into every step of what you do. We need to figure out what works and what doesn't, measure it, and collect data. This world, the world of civil legal justice, is under-resourced with data. It's very difficult to collect data on this, even on things like the number of unrepresented people in certain kinds of cases. In part, the data is hard because of the way our system is set up in the United States, where many of the matters that I'm most concerned about in my work, housing matters and family law, are matters of state law, and there are 50 different systems out there. But we need to evaluate, and if innovations that we're coming up with are not making a difference, we need to move in a different direction. But evaluation needs to be critical. Now, there's some great work going on in this field. There's a professor at Harvard Law School named Jim Greiner, who is now running something called the Access to Justice Lab. And what it attempts to do is to measure the efficiency and the effectiveness of various interventions in the world of civil justice. And what he does is he uses what's called the gold standard of evaluation, randomized controlled trials. This is a method of evaluation that's most often thought of in connection with the medical world, pharmaceutical companies, where they will test a medical intervention or a new drug on a population of people, compare it to a group of people who didn't get the intervention or the drug, and see what difference it makes. He's applying that kind of thinking to interventions in civil legal aid. And what it shows is some things work and some things don't. Sometimes people actually don't want to hear that. They don't want to be told that what they're doing is not very effective. I'm not sympathetic to that view. Don't you want to know? Why would you want to continue to pour limited, we function in a resource-starved environment. We need to be getting the biggest bang for our buck and be sure that what we are doing is effective, and if it's not, do something different. So those are my 4 recommendations, that we think about priorities, process, who's at the table, and evaluation. This is doable. There is no reason why anybody should look at this problem and say it's too big and it's unsolvable. We got ourselves into this situation. We can get ourselves out. And I think there is actually out there a lot of support for the idea. There's a recent study that was done that shows that there is widespread public support for improving the fairness of our justice system. This is the most fundamental of American values, equal justice under law. It's what our country claims to be about, what we hold ourselves out to the world to be. And when you poll people, you find they really believe it and they think it's important. The biggest challenge we face in turning that perception into change is ignorance of the problem. This is a great invisible issue in our society, the failure of our civil justice system for low-income people. I think there are a number of explanations for it. One is most Americans, not just, I know we have many people in the room who are from outside the United States. There are people who live in the United States who do not understand that you have no right to a lawyer in a civil case. In fact, studies show they think the opposite. They think you do have the right to a lawyer. I have my own theory for why they have that misapprehension. I think most Americans get their knowledge of the legal system from television shows. Most television shows are about the criminal justice system, not the civil. I think that many Americans could give you a pretty good approximation of a Miranda warning, including that part about having a right to a lawyer and one being appointed to represent you if you can't afford to pay for one, with no understanding that there is no such right in a civil case. They don't understand the difference between the civil system and the criminal system. Why should they? That's a lawyer's distinction. So one of the benefits of getting more people at the table, bringing in people from business schools and engineers and designers and social workers, is to educate folks about what's really going on and how our system is failing people, despite our nation's solemn pledge of justice for all. So I invite you to help. It's a tall order. It's doable. We can accomplish things. I'm so grateful to be invited to speak to you. I think what you do is exciting. This makes me optimistic, makes me positive. We're going to tackle this problem. Thank you all. Thank you. Do we have time for questions?
Yeah, I think we have time for one or two questions. If someone, just raise your hand if you have a question.
Just a minute. I've got the mic here. I haven't got it switched on.
Okay. Just raise your hand if you have a question. We'll start with you.
Could you just repeat the question?
Yes.
Yeah, more comments that it's actually pretty easy to get the force in viewers because they have this new nice. It almost looks like a headphones. So you should.
Yes.
Discouraged.
The comment was the situation in New York for uncontested divorces isn't as bleak as I painted it. There's an online chat box tool available to guide people through the preparation of the. Is that right?
Yeah, it prints out all the forms.
And
what's missing is the instructions.
Yeah. Okay. I'm confident I could find a similar example in another state that doesn't have that. So, yes.
A really good talk. Thanks so much for coming. I had the opportunity to work in the DC Landlord Tenant Resource Center
Yes.
about a year and a half ago.
Yes.
And one of the things that really surprised me, and I kind of wonder how you would address this issue, is there was a lot of concern around, we had these forms that guide people through the process. And if somebody else filled them out who wasn't a lawyer,
Yeah.
there was a lot of concern from the Bar Association and from other folks about unauthorized practice of law. And I know this question always comes up, but I was so shocked that that was where this was an issue.
Yes.
So you just say, okay, whatever. And I'm curious, how you would address that.
Yes. The question is from someone who had volunteer experience with the Landlord-Tenant Resource Center in the District of Columbia. The Landlord-Tenant Resource Center is a place where you can drop by on a day when you have a case coming up in court, and you can talk to a lawyer who isn't going to go into court with you, but can help you get your papers in order and work with you on identifying any defenses that you might have to an eviction. But the question is that his experience was that people who were not lawyers were not permitted to fill out the form for people for fear that they would be engaged in the unauthorized practice of law. And I think the concern is that seems a little silly. Yeah, that's silly. I think that one of the things that we need to do, one of the most important things we need to do, is to enable and empower people who don't have a JD degree and a bar membership to do something to help people. Some competent assistance is better than none. In the name of protecting consumers from the unauthorized practice of law, we've deprived them of any help at all. How can you hear the numbers that I cite about the number of unrepresented people and say, well, you know, we can't let non-lawyers help those people. What a disaster that would be. A lot of this is not rocket science. You can train people. If you want to certify them, have some kind of process to ensure the quality of the people that you're holding out to assist people. The good news is there is some progress being made there. There's a pilot program here in New York City to provide court navigators who go into court with someone. Now, there are limitations on what they can do. They can't respond to legal questions, but they can respond to factual questions from the judge. They can stand with the person in the courtroom and whisper to them. So you have some on-the-spot help. And there are similar pilot programs starting up elsewhere, basically modeled on what the medical profession has done to expand the use of nurse practitioners, RNs, physician's assistants, so that doctors are left to do the things that only doctors can do, and that people get the level of you don't need a doctor drawing blood from you. So I think we can take a lesson from that. Now, when there are moves to permit people who are not admitted to the bar to take on additional duties like that, guess where the opposition comes from? It comes from the bar. I'm not sympathetic, really. Lawyers take an oath to promote justice. And I think there's got to be a way to do better by bringing more people into the system if we're ever going to make our promise of justice for all real.
Hi, Jonathan Askin, professor at Brooklyn Law School. I don't know if you're aware, New York State is about to embark on considering writing a new constitution for the state. We've got about the most archaic constitution in the country. I know Legal Services has not weighed in on the merits, I don't think, of whether or not New York should go down this path. But if we were to, do you have thoughts on how to guide, what would you put, we've got about the worst judiciary in the country. And in part it's because we have this archaic constitution. Do you have thoughts on what we might want to include if we were to actually write a constitution, a forward-looking constitution for the digital age to make our judiciary and access to justice better in New York State?
I'm not sure what needs to be in a constitution, and I'd be careful about that because, as you know from your experience, it's very hard to amend a constitution. It may be that a number of the solutions that I advocate can happen by statute, by regulation. But I do think that, and I know that there was a resolution adopted by the legislature within the last couple of years here, I think at the instance of your former Chief Judge, Jonathan Lippman, to guarantee of access to the court system. At a minimum, I think you'd want to consider setting some kind of constitutional entitlement to justice. And, if you do that, you want to be sure that it has some teeth, that it isn't just meaningless words on a page that are not enforceable. Then if you're going to do that, you need to be sure you have funding to make it real. Because the promise itself, without the money to bring it to reality, is just going to raise expectations and disappoint people even further. So I think at a high level about what you might do in a constitution, but then be sure that you're doing things on the ground through your appropriations process every year to make it real. And I want to say a word of thanks and admiration to Chief Judge Jonathan Lippman. That man is a hero. He took it as his job as the Chief Judge of New York to improve access to justice. He thought it was his job as the head of the third branch of government, as the representative of the judiciary, to do something about the issues that I've discussed this morning. He was Chief Judge for only 7 years, from 2009 through 2015, but over those 7 years, because of his personal advocacy, state funding in New York for civil legal aid increased from about $16 million, I believe it was, to $100 million. One thing you might do, talk to Jonathan Lippman and see what he recommends. That's my most concrete advice.
Well, I can tell you that Jonathan Lippman is a supporter of the Constitutional Convention, and his key measure is to create a guarantee for representation in civil court.
Great. Okay, thank you.
Cool. Before we, Diana, come on up. We have an announcement before Dan gets on. Dan, do you want to get your computer set up while this happens? I want to do a quick sound check, though. Can you hear me in the back? You can hear me. Tarek, can you hear me? Can you hear me? No. No. Okay. Could you turn up the speaker a little bit? Yeah. That one works. Okay. Hello, hello, hello. Testing, test. Can you hear me? Good. Okay.
So, yeah, we could just turn the speaker around a little bit.
That's fine. Let's leave it there. Thank you.
The mic, back a little bit, and I might be able to push it a little further.
Great. Diana?
And then,
Thank you so much. We wanted to thank Dan Lear of AVO for the opportunity to invite you all today for the American Bar Association Justice Hack that is actually going to be in New York City at Fordham Law School next weekend, August 12th from 8 a.m. to 6 p.m. And it's actually the American Bar Association's Core J Commission, which is the Coalition on Racial and Ethnic Justice, is doing a justice hack so that we can work together to build applications, to build alliances between law enforcement and communities of color. So please visit, there's a meetup on Legal Hackers NYC that gives you details, but it is at Fordham Law School, and I'll be available here in case you have questions. But we really hope to see you, and we're really hoping that during our Justice Hack, we will be able to have an application, or at least the beginnings thereof, to make sure that we can really build alliances with communities of color and law enforcement. Thank you.
Ready to go, Dan?
Yes.
Excellent. Does every row have a sticky